in the matter of Darwall and another against Dartmoor National Park Authority.
Lord Stevens will hand down the judgment.
This appeal concerns a question as to whether the public have the right to pitch tents and to camp on the Dartmoor Commons. Members of the public wish to camp not in designated campsites, but anywhere on the Dartmoor Commons, so that they are away from crowds and from amenities and can enjoy the natural environment. Mr. and Mrs. Darwall own Stall Moor, an area of open land on the Dartmoor Commons. As stewards of land in their ownership, they are concerned as to the damage that camping can cause. In particular, they are concerned about the risk of fire and the damage caused to the landscape by those persons who camp irresponsibly. They are at pains to state that they are not motivated to stop all camping on Dartmoor Commons. Rather, they wish, as landowners, to be able to permit camping on their terms in order to mitigate the risks associated with a public right to camp at any time and in any part of the Commons. Ordinarily, as landowners, Mr. and Mrs. Darwall would have the ability to control camping on their land. However, the rights of the public in relation to the Dartmoor Commons are now to be found in the Dartmoor Commons Act 1985. I will refer to that act as the 1985 Act. The issue in this appeal is a matter of statutory interpretation. Does Section 10, subsection 1 of the 1985 Act give the public a right to camp on the Commons? If it does, then Mr. and Mrs. Darwall, as landowners, cannot prevent any member of the public from camping on Stall Moor. Rather, they would have to rely on the Dartmoor National Park Authority, if that authority thought it appropriate to do so, to control camping by, for instance, making bylaws. Insofar as relevant for the purposes of this short summary, Section 10, subsection 1 states that, subject to the provisions of this Act and compliance with all rules, regulations, and bylaws relating to the Commons, and for the time being in force, the public shall have a right of access to the Commons, on foot and on horseback, for the purpose of open-air recreation. The dispute between Mr. and Mrs. Darwall and Dartmoor National Park Authority is as to whether Section 10.1 confers on the public a right to camp. Mr. and Mrs. Darwall contend that the open-air recreation in question must be of a kind which is carried out on foot or on horseback. If that interpretation of Section 10.1 is correct, then the public do not have a right to camp. However, Dartmoor National Park Authority contends that the words on foot or on horseback simply state the means by which a member of the public gains access to the Commons, and those words on foot or on horseback do not restrict the forms of open-air recreation, such as camping, which may be enjoyed by a member of the public once they have gained access to the Commons. To resolve this dispute as to the correct interpretation of Section 10, subsection 1, Mr. and Mrs. Darwall brought these proceedings against the Dartmoor National Park Authority, contending that their interpretation of Section 10.1 was correct, and seeking a declaration that Section 10.1 does not grant the public a right to camp on the Commons. At first instance, the High Court agreed with Mr. and Mrs. Darwall that Section 10.1 did not grant a right to camp. However, the Court of Appeal disagreed and held that Section 10.1 did confer a right to camp on the Commons. Mr. and Mrs. Darwall now appealed to the Supreme Court, which unanimously dismisses the appeal for the reasons set out in a joint judgment given by Lord Sales and me, with which the other justices agree. I will now briefly summarise the reasons. The courts, in conducting statutory interpretation, are seeking to ascertain the meaning of the words used in a statute in the light of their context and the purpose of the statutory provision. The starting point in statutory interpretation is the wording of Section 10(1) itself. The Supreme Court considers that it is possible to arrive at a clear understanding of the true meaning of Section 10(1) by focusing on its wording without the need to refer to other aids to interpretation. There are several indications in Section 10(1) that members of the public who have entered the Commons on foot or on horseback have a right to camp on the Commons. It is sufficient for present purposes to refer to 3 of those indications. First, as a matter of ordinary language, camping is a form of open-air recreation. Second, the opening words of Section 10(1), which makes the right of access subject to the provisions of this Act and compliance with all rules, regulations, and bylaws, contemplates that the primary restriction of the right of access is by forms of regulation, which at the time the 1985 Act was passed, did not prohibit camping. Third, the words on foot and on horseback describe the means by which the public are to have a right to gain access to the Commons. The wording of Section 10, subsection 1, is sufficient to hold that the correct interpretation is that contended for by the Dartmoor National Park Authority, and that the appeal should be dismissed. However, other provisions in the 1985 Act reinforce the conclusion that members of the public who have entered the Commons on foot or on horseback have a right to camp on the Commons. For example, the long title of the 1985 Act states that it is an act to, among other things, regulate public access to the Commons. The reference to public access is unqualified, which tends to indicate that what is being regulated is public access for a wide range of activities. As an aid in support of their interpretation of Section 10, subsection 1, Mr. and Mrs. Darwall sought to rely on statements in Parliament as recorded in Hansard. However, those statements are inadmissible, as the wording of Section 10, subsection 1 is clear. Another aid to statutory interpretation relied on by Mr. and Mrs. Darwall is the principle of legality, according to which courts should be slow to impute to the legislator an intention to override fundamental rights where that is not clearly spelled out. Mr. and Mrs. Darwall argued that the right to protect their own private property by pursuing an action in trespass against individuals who camp on their property could only be restricted by clear statutory wording. However, the wording of Section 10(1) is clear, so the principle of legality does not assist. A statute may limit the rights of property owners, and that is what has happened here. That is a short summary of our reasons for dismissing this appeal. However, there is a further matter to which we refer in our judgment. Mr. and Mrs. Darwall sought a declaration that Section 10, subsection 1, did not grant the public a right to camp on the Commons. Yet, the public was not represented. Typically, the public is represented by the Attorney General. Except in special circumstances, all interested persons should be made parties before a declaration affecting their rights is made. Therefore, a declaration purporting to bind the public should not have been made by the High Court unless the Attorney General had been joined as a defendant in the proceedings. In conclusion, the appeal is dismissed.
Thank you.
Judgment in the matter of URS Corporation Limited against BDW Trading Limited.
Lord Burrows will hand down the judgment.